Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, performance test, reading the library, extracting rules from cases and statutes, and building your rule framework. Let's begin. The library is the legal universe of the performance test. It provides the authorities you must use and the only authorities you need. A library may contain statutes, rules, regulations, constitutional provisions, cases, jury instructions, agency guidance, or excerpts from treatises. Your job is not to memorize these materials. Your job is to extract the governing rules and build a framework for analysis. A strong PT answer uses the library actively. It states rules accurately, organizes them logically, explains how authorities fit together, and applies them to the file. A weak answer either ignores the library, copies long passages without structure, or summarizes cases without deriving rules. The grader wants to see legal reasoning, not transcription. Cases in the library usually serve a purpose. They may define an element, interpret a statute, create a test, illustrate how facts satisfy or fail a standard, provide exceptions, or show how courts weigh competing policies. Statutes often provide the basic structure, while cases explain how the structure works in real life. Sometimes the library includes a majority rule and a distinguishable exception. Sometimes it includes two cases reaching different results, so you can compare your facts to both. Rule synthesis is the key skill. Synthesis means combining authorities into a usable statement of law. Instead of writing 3 disconnected case summaries, you might write, a claimant establishes reasonable reliance by showing a specific representation, awareness of the representation before acting, and conduct that would have been different absent the representation. Reliance is less likely when the claimant had equal access to contrary information or ignored a written warning. That synthesized rule is more useful than a paragraph reciting case names. Start by identifying the hierarchy of authorities. If a statute and cases are provided, the statute may supply the elements, and the cases may interpret them. Read the statute for structure. Break it into numbered elements, requirements, exceptions, deadlines, and remedies. Next, read cases for function. Do not brief every procedural detail. For each case, extract 5 things: the legal issue, the rule or interpretation, the key facts, the holding, and the reason those facts mattered. Write this in shorthand. For example, Case A, no waiver where delay 2 months, no prejudice, defendant reserved rights. That note is more useful than a full case brief. Then group authorities by issue, not by order of appearance. The library may present cases in historical order, but your answer should be organized by the task. If 3 cases discuss one element, bring them together. If one case discusses 2 issues, split its rules into the relevant sections of your framework. Create rule statements at different levels. Begin with the umbrella rule, the overall test or claim. Then add subrules, elements, factors, burden, exceptions, presumptions, remedies, or standards of review. Finally, add application guidance, examples of facts that satisfied or failed the rule. This layered structure helps you write quickly. Use case facts strategically. In the PT, case comparisons are powerful because the library cases are invented or selected to guide your analysis. When your facts resemble a case, say so. When they differ, distinguish them. For instance, unlike Rivera, where the employer gave only a vague oral warning, Greenbox provided a signed acknowledgement explaining the exact policy. This shows the grader you understood both the rule and its application. Avoid overquoting. Short quotations can be useful for exact legal standards, but long copied passages consume time and can make your answer look unprocessed. Paraphrase accurately in your own words. If a statutory phrase is central, quote that phrase and then explain it. Watch for burden and standard. Who must prove the issue? By what standard? Must the court find reasonableness, substantial compliance, good cause, materiality, prejudice, or likelihood? These terms shape the answer. A fact that creates uncertainty may be enough under one standard and insufficient under another. Note mandatory versus discretionary language. Must, shall, and is required usually signal mandatory rule. Identify policy reasons. Cases often explain why the rule exists, preventing surprise, protecting reliance, encouraging settlement, avoiding forfeiture, preserving judicial efficiency, or deterring misconduct. Policy can help when facts are close. Use it briefly to support application, especially in persuasive tasks. Before writing, convert your notes into headings. If the library creates a 3-element test, your discussion may use those 3 elements as headings. If it creates a balancing test, your headings may track the factors. Good headings make your answer easier to grade and easier to write. Suppose the library includes a statute stating that a court may set aside a default judgment if the movement shows mistake, diligence, and lack of substantial prejudice to the opposing party. Case 1 holds that a calendaring error by a legal assistant can be mistake when the attorney had a reliable system and the error was isolated. Case 2 holds that waiting 4 months after learning of default shows lack of diligence. Case 3 holds that prejudice means more than having to litigate. It includes lost evidence, unavailable witnesses, or changed position. A poor answer would summarize each case in separate paragraphs and then conclude. A strong rule framework would state, to set aside default, the movement must establish 3 requirements: qualifying mistake, diligence after discovering the default, and absence of substantial prejudice. A clerical calendaring error may qualify if it occurred despite a reliable office system, but not if it reflects general neglect. Diligence is measured from discovery of default, and unexplained multi-month delay weighs against relief. Prejudice requires a concrete litigation disadvantage, not merely the burden of defending the case. That framework is ready for application. You can plug in file facts about the office system, date of discovery, date of motion, missing documents, and opponent's claimed prejudice. One mistake is reading cases like law school assignments. You do not need full procedural history unless it affects the rule. Another mistake is copying rules without organizing them. The grader needs a framework, not a pile of quotations. Students also miss exceptions and limitations. A statute may appear broad, but a case may narrow it. Some students fail to compare case facts. PT cases are included to guide analogies and distinctions. Use them. Another mistake is using outside law terminology that conflicts with the library. If the library defines the test differently, follow the library. Spend about 18 to 22 minutes on the library in most PTs. Read actively with a rule extraction mindset. Mark elements with numbers, factors with letters, exceptions with stars, and helpful case facts with brief labels. Stop when you have a usable framework. Do not chase perfect notes. If time is short, prioritize the most authoritative and task-relevant materials. A statute and the case interpreting it are usually more important than background commentary. But do not ignore a short case that appears designed to match the file facts. The library supplies the only law you need. Break statutes into elements, conditions, exceptions, and remedies. Read cases for rules, key facts, holdings, and reasoning. Synthesize authorities into a usable rule framework. Compare and distinguish library cases when applying file facts. Organize your answer around the framework, not around disconnected case summaries. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.